part heard appeals in the matters of the King on the application of E.ON and others and the Secretary of State, and the King on the application of British Gas Trading Ltd and the Secretary of State.
With the Court's permission, I'll turn to ground 3.
Yes, just before you do that, Mr. Beale, a couple of points. One is thank you very much for the transcript. We would actually welcome having it in electronic form as well, and we would have welcomed having it in electronic form last night. So if whoever's kindly doing it could ensure that happens, but thank you. I gather we've had a request, despite their heroic efforts yesterday from the transcript writer, to have a break in the course of the morning. We will have one, but it will be genuinely limited to 5 minutes, because what tends to happen is one says 5 minutes, it's always 10. So we'll have it as a natural break. The other point I just wanted to pick up from yesterday, I floated in the course of argument the possibility that the phrase judicial review in the footnote to whichever article it is, to the TCA, doesn't mean judicial review in the sense defined in the 1981 Act. I would be grateful if one of the teams behind you could just do a bit of work on discovering whether it is used elsewhere in the TCA or in analogous EU legislation. I know this isn't technically EU legislation, yes, but it clearly has an EU background, or indeed even international law, in a context which makes it clear it doesn't mean necessarily, it just means review by a court, it doesn't mean judicial review procedures. Yes,
I've got 2 immediate responses, if I may, to that point. Firstly, Malona Junior, Ms. Patel did a search electronically on the treaty yesterday, and yes, it does appear in other places, and the same term is used, indicating that it doesn't have a bespoke meaning.
Well, I think it'd be useful if you could just turn that into a very short note, ideally an agreed note, but if not, at least a note. Thank you. That was your first response.
That was my first point. My second point is, because the treaty expressly envisages that national court procedures are primarily for the domestic regimes of each trading bloc, it's highly unlikely to have a bespoke meaning by reference to one or other of the domestic
that was certainly my initial view, but if, I'm not sure in the end of the day how important it will be, but if it is important, we need to bottom it out and have the material to write a paragraph saying so. Of course. Rather than just assuming it. So
we'll put that on our homework.
If the respondents take a contrary view, they can be getting on with their homework on that.
Yes.
Right.
Thank you very much.
Sorry, Mr. Beale, before you launch to ground 2, can I just clarify where we got to get by the end of yesterday on ground 2?
Yes.
What your case is. As I understand your case, it's a very simple one. Article 366 produces a hard-edged question. Therefore, it's for the Divisional Court itself to determine for itself whether the principles were satisfied, in particular, principle B, I think, proportionality and least required. If that's right, then all the arguments about proportionality as a standard of review, light touch, heavy touch, are completely irrelevant, aren't they? Because it's a question the Divisional Court had to decide for itself.
The Divisional Court had to decide for itself, and the position from Dalston is that the decision-maker's decision is necessarily going to be reviewed, but that goes to the weight to be afforded to the decision when the court is taking its own view as to whether or not the subsidy is proportionate. So I think
jump into my lord's ready. Yes, but I think the weight of his point was that an awful lot of the submissions we've had about light touch, heavy touch are just conceptually irrelevant on your submission. Is that right? Or you...
Well, my sense, if I may put it this way, of the case law is that there's been a degree of confusion between the concepts of weight and margin of discretion. Formally, the subsidy is either going to be proportionate or not, and that is the legal issue that the court will grapple with. In the course of grappling with it, it will necessarily look at the decision-maker's decision, but the court is taking a decision of its own volition as to whether or not the proportionality standard has been met. In the course of taking that decision, it will look at the decision and it will give that decision such weight as the context calls for.
That's a different point.
Well, the difficulty with... I'm afraid, trying to stick to the analysis of Lord Justice Singh in the Dalston case, paragraphs 19 and 20, and I'm trying not to divert from that because...
and he does say there that the case law is in a bit, until he spoke, is in a bit of a muddle.
That is what His Lordship illuminatingly recognises, that people have been using different tests to say different things. I think in practical terms, as Lord Bingham said as long ago as in the Supreme Court, maybe even the House of Lords, I can't remember whether that was pre the Supreme Court or not, proportionality is for the court. The court won't shy away from finding that a decision is disproportionate if that's the conclusion that the court reaches. And it depends on the facts what weight is afforded to the primary decision maker, careful with that word, the executive decision that's been taken and that is subject to review before the court. What I don't say is that it's for this court to look at all the evidence and reach its own conclusion as if it were engaging in an executive act. That's clearly
In this court, I mean,
or the divisional court.
well, because there's a separate question about appeal, which would,
Yes.
I was going to raise when my lord's got his answer. The ground is framed as a misdirection or application of the wrong standard by the Divisional Court. It follows, I assume, maybe you say so explicitly, I haven't checked, that you are inviting us to apply the right standard
Yes.
to the material before us,
Yes.
and to you're inviting us to find that it was in fact disproportionate.
Yes, I am. By reference to the primary facts as found by the Divisional Court, I'm inviting you to reach a different evaluation as a matter of law as to whether or not the subsidy control principles were met. I am going to go now through the judgments of the Divisional Court to show you how they dealt with the proportionality issue and whether or not there was indeed an open, non-discriminatory and competitive process. I will dip into the odd document, especially where our contention is that the court's evaluation of that document was demonstrably wrong. But that's only going to occur in a couple of places. So the main submission on ground 3 is that there was a market distorting subsidy that was granted to one competitor in an otherwise competitive market. It was granted on the express premise. See the documents I took the court to yesterday, the SCA and the AOA, the two assessments. It was granted on the express premise that there had indeed been an open, non-discriminatory and competitive process, not just for selecting the beneficiary, but for determining the nature and extent of the subsidy to be awarded. We say that the Secretary of State's basis for concluding that the subsidy was the minimum necessary to achieve the objective was flawed. Its proportionality has not, therefore, been demonstrated, and this court should rule that the subsidy was disproportionate and therefore unlawful. Now, the key issue I'm going to cover in the next half an hour or so is a review of the court's conclusions as to the process that was followed. It's worth reiterating, however, that the Secretary of State did not in fact say in terms that the relevant subsidy control requirements were met through the marketing procedure that was adopted. He simply said he was entitled to take the view that the M&A process that had been followed satisfied those criteria. And it's also noteworthy that the court itself, paragraph 252, only concluded that the Secretary of State had been entitled to form the view that the relevant criteria were met. So, if I could start, please, looking at how British Gas had actually put in a formal bid for bulb before this entire process was started. This is dealt with in Mr. O'Shea's evidence. The court will find that in Supplemental Bundle 1, tab 9, page 261. And I'm going to give you a confidential figure. Paragraph 10, please. That's bottom of page 261.
Which bundle?
Supplemental Bundle, Volume 1, tab 9, page 261. The bottom of that page. Mr. O'Shea explains how before bulb went into Energy Supply Company Administration, it appeared to be British Gas generally to have good brand value, and we thought there was perhaps still material value in the company. While we did not know where the value lay, we were keen to explore that question. On 6th of October 2021, British Gas submitted a non-binding offer for the entire issued share capital of Simple Energy Limited, the parent company of Bulb, for a value range of, and then there are two figures that I'm not going to read out. The rationale for this offer was set out in other evidence. It was made in the usual way, subject to due diligence and on the assumption and basis of discussions with management and the department, where appropriate, would continue. British Gas's discussion with management and Lazard about a potential transaction continued following the offer, but the terms of any final and binding offer would have to have been signed off by the British Gas board. So that's the range value that British Gas was assigning to the business. And of course, that was then interrupted by the Energy Supply Administration. Now, therefore, at the very start of the so-called M&A process, it was recognised that there were significant difficulties with hedging exposure and loss-making customers. In short, it was well known that the value of the business was essentially negative, and indeed, as it turned out, deeply negative. This becomes clear from paragraph 28 of the judgment, which is in Core Bundle tab 7, page 102, and 28 of the judgment records the JEA circulating a paper right at the outset, December 2021, discussing the options for how to deal with the sale of Bulb. And it raised the question of whether or not a dowry would be necessary. The last sentence of that paragraph, it was noted that the timing of exchange and completion would likely be dependent on the quantum of any funding required by a purchaser, either provided directly to the purchaser by the department or via Bulb to acquire loss-making customers pre-April 2022. So right at the start, it was recognised that some form of funding was going to be necessary. At paragraph 30, the court then went on to look at what it described in subparagraph Roman 2 as a major theme of the sales process. Lazard and the JEAs, the professional advisors, were expressing the view that some form of government funding would be necessary to close a transaction.
So, sorry, where are you reading from now?
Roman 2, top of page 103.
Yes, thank you.
Concern was that if HMG was seen to be too forthcoming, it would not secure the most advantageous offer. But of course, you have my submission from yesterday that if you don't say government funding is available, you may well deter people from making any bids at all. And indeed, that was the guidance that was given to the department, see sub-Roman 4. If you don't say anything about this, you risk everyone simply saying it's unaffordable. That was the position, see paragraph 32, that was maintained all the way through to February and afterwards, notwithstanding the invasion of Ukraine by the Russian Federation, as the Divisional Court describes it. The department was saying to its professional advisors, make sure that Lazard do not publicise these options for financial structure. So they weren't allowed to say funding will inevitably be available, and we'll deal with the two issues that I identified yesterday, which were proving to be intractable in securing a market solution to this sale, by which I mean a free market solution. Now, the Operations Board itself was also aware of the need to consider subsidy control issues. We see at paragraph 33, the department prepared an exit strategy update paper, said that we need to maximise the recovery from sale value and so on. And then over the overleaf it says, given this construct, the JEAs and Lazards will be responsible for undertaking the assessment of M&A bids, but the relevant exceptions, which aren't cited in the excerpted text, related to financial structures, i.e. reliance on a portion of HMG funding remaining in the company, and subsidy control, namely that if any value came from government funding and was left in the company when it was sold, then subsidy control principles would have to be applied. Now, the exit strategy paper that we can then dip into, with your permission, bundle 3 of the supplemental bundle, at page 557, tab 32. This is an exit strategy paper from March 2022. At 557, there's a table, and it deals with financial structures, reliance on a portion of HMG funding remaining within the company. There's then a separate section on subsidy control, where it says if any value coming from the government funding is left in the company when it's sold, it may need to be considered.
Sorry, where again?
3 rows down, my lord, subsidy control in the
3 rows down on page 555.
557.
557.
I'm sorry.
Yep. Yes, okay, of course. Thank you.
3 rows down in that table, right-hand side, if any value coming from the government funding is left in the company when it's sold, it may be considered a subsidy, therefore fall into the subsidy control regime. This may be for the successful bidder and their bid profile, or more generally at the sector level, given the interaction. We then see the details of the tax loss and subsidy control, next paragraph down, 2 paragraphs down, are to be developed and worked up over the coming weeks. And second to last paragraph on the page, there's an indented section that begins, however, in the context of the recent Russia-Ukraine escalation and resulting wholesale price increases and volatility, we consider it much more likely that we will need to utilise such structures. So the need for government funding to get this over the line was becoming increasingly recognisable. It was recognised that subsidy control issues would have to be applied, but there was then the schism I referred to yesterday between the person responsible for conducting that subsidy control assessment, namely the government, and the person conducting what was effectively an M&A process akin to a private sale, namely the JEAs with the benefit of Lazard. Going back, please, to the Divisional Court judgment, if we could pick it up, top of page 105, paragraph 39.
Sorry, say again, which paragraph?
Sorry, paragraph, I've given myself the wrong reference. It's paragraph 36 on page 104. I'm so sorry, I wanted to go to the, before I go to E.ON withdrawal, I wanted to go to what the bid letter, phase 1 letter said. So paragraph 36, 19 parties who had signed non-disclosure agreements were sent the phase 1 letter. The phase 1 letter stated, there is optionality for interested parties on the scope perimeter of the potential transaction, and we invite interested parties to indicate both how they would bid on the indicative transaction structures and whether an alternative transaction structure would be preferred. It says nothing about the 2 elephants in the room, namely the very substantial debt that Bulb had, nor indeed the need to provide hedging for the winter wholesale prices. That is simply not covered.
Could you read 39, which you mentioned?
I'm coming on to 39. My learned friend will be pleased to hear I'm about to come on to 39. And so that essentially led to that lack of information helps explain why E.ON withdrew for the reasons given. And they identify the 4 reasons why they are not moving forward with a bid at this stage. They then say, we observed this response, which raised the possibility of a mitigation mechanism. We observed that this response expressed a positive anticipation that there would be a mitigation mechanism for volatility in the absence of a hedge, which realistically could only have been understood as some form of government support. But with the greatest respect, it's hard to see why what E.ON was told after it had withdrawn from the process could credibly be seen as a substantial and credible offer of financial funding to the tune that we've seen. With the greatest respect, that conclusion simply doesn't follow. And in any event...
So what conclusion doesn't follow?
The conclusion that somehow the text that is contained in the Lazard communication to E.ON after they're pulled out is an offer of government funding being available.
Well, it's not an offer, but it is clearly an indication that if you're interested, this is something that we would make available in some form. Well, it depends what you mean by offer, but it couldn't be clearer, really, what they're saying.
What it's offering is a mitigation mechanism of an unspecified nature and an unspecified extent. And subsidy auctions are not, with respect, meant to be a guessing game. We think you might be offering something. What is it that we are meant to take that to mean? If there was a clear, transparent, non-discriminatory approach at this stage, or shortly after this, certainly when phase 1 produces only 2 outline bids going through, if it's recognised that government funding is indeed necessary to get the transaction over the line, there should have been a revised offer letter going to the bidders saying government funding will be made available to cure the two obvious deficits that are standing in the way of a transactable transaction for Bulb. And that revised offer letter would have then put everyone on the same level playing field. And that's not what happened.
And that's, at what point should such a letter have been sent?
Well, it's obviously within a range of when it becomes overwhelmingly evident that a market-driven process is simply not going to produce a satisfactory outcome.
Well, what do you mean by that?
Well,
it could produce a satisfactory outcome if a bidder said, we'll do this, but we need some level of support, which could be provided.
Well, the difficulty with that, my lord, is that if you have one bidder who is prepared to put in a bid saying, I'm prepared to offer £1 for this company, but only on the basis that you give me £1 billion worth of subsidy, that bidder is chancing its arm in circumstances where what the government should be saying is government funding will be provided, but the nature and extent of government funding will be subject to a bidding process. Therefore, you are encouraging people to bid for the least amount of government funding that will be necessary to get the transaction over the line. And that's what happens in all the other subsidy auctions in this field. Contracts for difference, the capacity mechanism, they're all conducted on the basis of an open auction process with bids going in, where effectively the mechanism of the auction ensures that the least amount of subsidy will necessarily be provided to the winning bid, because it drives down the amount of subsidy that has to be funded by taxpayers.
So you say once it became evident that no one was going to make a bid which did not require some funding,
Yes.
then at that point the whole market had to be gone back. The whole market?
Well, those who had signed NDAs with the organisers of the process would have been the obvious ones to send a revised process letter to. So a revised phase 1 letter, as one sees at paragraph 36, saying in terms, government funding will be made available because we recognise the very heavy debt and the wholesale hedging issue. Government funding will be made available, but we expect you to include within your bid precisely what your demands from the government are, with a view to driving down the level of demand that is made for taxpayers' money.
Why stop there? Why just the 19 who signed NDAs? Because if now the tender, as it were, is going out on the basis there will be government funding, why shouldn't it go back to everyone?
Well, I can see why if you're not within the 19 and the only reason you didn't respond to the initial marketing offer, I can see a case being made by a disgruntled bidder in that situation that my lord's point would be right. They would have to go back to the initial people that they had approached right at the beginning of the phase. But it's telling that in different contexts, wherever there is a subsidy auction, it's publicised on a department website. And so when you want to bid for the contracts for differences, you fill in a form on a website that's freely available to anyone. Instead of that process, what we ended up with was a selective re-engagement with certain strategic bidders only.
And what should this revised approach have contained? Not that it couldn't contain the details of what support was on offer, because that all depended on what bidders wanted.
Yes.
So it would have been no more than
it would have been
prepared to consider.
It would have been that the government will provide support to cater for what's then clearly to be recognised, that the bulb is a negative value proposition as a business, and so government recognises that support will have to be provided to effectively wipe out the debt and cater for the absence of a commercial hedge for a given period. And that is essentially, when we looked at the so-called Quantoc email yesterday, that's essentially what Lazard's was saying to Octopus. Because Octopus went into those communications with Lazard saying, well, we've got a real problem here with working capital and with the value of the business.
Just spelling out, the offer letter should say something to the effect, government will provide support. And the next sentence would be, bidders are invited, or interested parties are invited to make proposals for the form of support that they would require,
Yes.
form and quantum.
Yes. And then you have an open, transparent process of bidding for the least amount of government funds that are needed to get this transaction over the line.
Sorry, so that's slightly different to your answer to my question a moment ago, because your answer to my question was that it should say the government will provide support to wipe out the debt
Well,
in case of the absence of a I provide a hedge.
the government should have made clear that the two problems facing the free market sale of this business were the two problems I've identified. And logically, given that you're trying to cure the absence of a valuable market price for this business, you need to deal with what is stopping it being a valuable business. And that is whether it was spelled out as specifically being debt of X or hedging cover of Y, it would need to have identified that those problems, these are the problems that are getting in the way of a transactable transaction, those problems would be dealt with by support. And then to my Lord Justice Underhill's point, the bidders could have been invited to say how they would deal with those particular problems with the government support that they required.
Well, not how they would.
What their proposals were.
That's not quite what I said. I said they've been asked to identify the form and quantum
Yes.
of the support they would want to deal with those problems.
That's what I was seeking to clarify. So the difficulty is if you don't have a situation in which the government comes clean that it will inevitably be stumping up a large sum of money, then people are shooting in the dark as to what the consequences of the transaction are. And you will have some people who will say, well, this is impossible without government funding, therefore I need government funding, but don't know whether or not that government funding is realistically available. And so British Gas, for example, when they submitted their bid, said that they were anticipating a proposal from Her Majesty's Government, His Majesty's Government, see paragraph 46 of the judgment. We know that when Tulip put their bid in...
Hang on 1 second. With 46, which subpara?
Subparagraph 1, British Gas's bid noted that we understand Bulb remains largely unhedged and the valuation of the exposed volume is material. Finding a treatment of this exposure that is acceptable to all parties will be an important factor. We would seek to engage with government on this. So if the government had said to all interested parties, we will be engaging with people to find an outcome that will deal with the unhedged exposure and the large debt, then people could have actually been structuring their bids, taking that into account and specifically making their demands known to government. We then see it was British Gas also stated it is understood that Lazars and the JEAs will be in contact with the government and may develop a position on acceptable transaction structures. Now, when you're dealing with something that self-evidently is going to require government funding, this should have been upfront and in the process letter. It should have been made clear that the government will find a way, through transaction structures, through financial structures, and with government support, of dealing with the two problems that were stopping a market deal going ahead.
So BGT understood the very thing you say should have been communicated to the market.
Well, British Gas understood that unless government funding was made available in some form, it wasn't realistic to expect that there would be a market solution to this problem.
It's expressly relating to hedging.
Well, they thought that they would be engaging with government in order to find a solution to the hedging issue.
Yeah, well, sorry, I want to continue.
But the difficulty with that is that the government then never engaged with British Gas specifically on what would be available. So British Gas got no further indication. When British Gas met with the Secretary of State, the Secretary of State essentially said, what's your best offer? And that isn't him saying funding will be made available on terms that we will negotiate.
Well, they perfectly possible for them to say, it being clearly understood that they would need support to deal with the hedging for the moment. Our best offer is X million or £1, doesn't really matter. Subject to hedging support for the unhedged according to the following formula. They could propose any formula they liked, from an absolute guarantee to something in between, to something more sophisticated.
The difficulty, my lord, is that there was no indication that government funding would be, in fact, available. There's
you don't have to read very much between the lines to see it. It was pretty clear there was an indication.
Well,
That's on the JEAs will be in contact with the government.
So what's being proposed is that British Gas's final bid would necessarily turn on further conversations. And we know from the Octopus bid, I mean, it's stark, Octopus didn't put in a bid at this stage.
No.
Octopus, see paragraph 48, Octopus took the view that economics make investment into renewable generation and EV business more compelling than retail. They were pulling out. It was too risky.
Suppose it had said explicitly, the government had said explicitly, or more explicitly than it did, we recognise there's a problem in these two areas. We're open to suggestions as to what support we might give, but we look to you to propose what kind of support you're looking for.
Yes.
That would have been all right, would it?
That would have enabled the parties to effectively bid for the level of government support they needed. It would have been a recognition that the government, it would have been the recognition that ultimately Octopus
Wasn't that
was given.
apparent anyway?
No, my lord. Because we know Octopus initially pulled out, so it wasn't apparent to them until the re-engagement process. E.ON had pulled out, and we know from Tulip that Tulip had said in terms, we are making this proposal, but we think, see sub-Roman 5, paragraph 46, Tulip's bid stating we are also considering a potential option for the government to continue funding the business throughout the summer price cap period. So Tulip had therefore flagged up the needs, as the Divisional Court found, for potential government support. But the trouble is everyone is anticipating that there might be government support. What they should have been told was that government support would be made available, the amount and nature thereof to be determined.
Well, that's a tiny difference, isn't it? Is it really a material difference at all?
Well, it is, my lord, because some people were not putting in bids on the basis they didn't think government funding would be available. And we know from the Tulip email we looked at yesterday, even in bid 2, even for the phase 2 process, when Tulip pulled out of that, they did so on the express understanding that they thought that government funding would be needed, but there was no indication that government funding would be made available. So that the participation of the bidders is highly sensitive at this stage to assumptions being made by certain bidders and not others. And that is the antithesis of an open procedure. It shouldn't be a tacit game of cat and mouse between the government not wanting to lead people on and the courageous mice deciding that they can get something past the cat.
And yet, you're not part of your case the government should say anything in particular. It should just use the formula there will be some form of support available.
It should use the formula that the debt of Bulb and the working capital requirements of Bulb for the winter period will be catered for by government funding.
What does catered for mean?
Well, it means that they will be addressed effectively so that you have instead of having a negative value proposition business, you have a business that can be bought for at least £1, which is what...
Even that's a bit meaningless, isn't it? Because someone may well take a business which has a negative valuation at this moment, but on the basis that they make a commercial judgment that the advantage of huge market share or a view they take of the market development of the market over the next X years is that we're prepared to buy a negative value business at the moment.
But the debt position here and the exposure to hedging was so significant that nobody was making a market-driven bid for this business. It was the only bids that were coming in were saying, well, we are prepared to move to the next stage, see British Gas, but if we look at Roman 3, the Divisional Court finds it was clear to British Gas that there was scope for discussion with HMG as to the support that would be required, albeit British Gas was anticipating a proposal from HMG. The point is British Gas shouldn't have been trying to work out in a game of cat and mouse exactly what might be on offer in circumstances where, had they been told in terms, government funding will be made available to cure the obvious problems of very high debt and unhedged exposure, the parties then could have quite properly bid on the minimum necessary to deal with those issues. And so, as I said yesterday, British Gas, for example, coming from a position of it being a highly subsidised, highly capitalised business, would not have needed as much working capital support from the market as a less capitalised business. So it's also important, my lord, to note that this is a case in which the government accepts it was giving a subsidy. And the issue really for this court, as it was for the Divisional Court, is it right that the subsidy that was in fact made available was the minimum necessary? Is it therefore right that the subsidy is proportionate or disproportionate? And that entirely depends on whether or not this court is satisfied that the procedure that was followed was sufficiently open, transparent and non-discriminatory, that bidders were properly bidding for the minimum amount of taxpayers' money that they needed. And if this court is not satisfied that this process, as described by the Divisional Court, enables that conclusion to be drawn, then there is non-compliance with the subsidy control principles. So that, in a nutshell, I'm going to carry on, if I may, tracking through the process, but that in a nutshell, is our submission on this part of ground 3. Essentially, when only 2 non-binding offers were received, it should have been readily apparent that the eliciting a market-led bid had failed. There was then selective re-engagement, see paragraphs 50, 57, and so on, leading to the conclusion at 59 that it wasn't clear on what basis the parties were chosen for selective re-engagement.
It's not quite true. It's not. There's the phrase "not entirely clear," but then they go on to be satisfied of the process that was in fact followed.
Well, my lord, it was for Lazards, essentially, to work out who the key strategic participants were. You can see who they selected to fit that bill. That bill did not include E.ON. The Divisional Court then goes on to say it's satisfied that Lazard was entitled to take the view that E.ON should not be reapproached. But again, what this doesn't show is non-discriminatory treatment on the level playing field basis of all the bidders, who are not being told essentially what Octopus was then told in the Quantock email, and they're not being told, as Tulip was, that there is a structure that we can think of which would deal with the hedging issue.
So the question of who to reapproach is a judgment-driven one by the person at the centre of the process. Your complaint, however, I think, is not that they chose the wrong people. They should have gone to everybody.
Yes.
That's it, is it?
Yes. Because what they were doing was trying to engage the private sale process. They understandably were not seeking to apply the subsidy control principles, and they therefore weren't seeking to ensure that there was an open...
See, understandably we're not seeking to apply.
Because they're trying to sell a business in insolvency. They're doing a standard M&A process. I'm not criticising them for that.
Yes, I see, sorry.
I'm simply saying there's a schism between control of the process and responsibility for compliance with the subsidy control principles. Yes. Mr. Peretz points out that they are subject to separate statutory requirements to conduct that process under the Energy Acts, but of course, they, as I showed you yesterday, Mr. Cowlishaw said, well, I wasn't in charge of dealing with subsidy control points. That wasn't for me. My job was to get the sale done as quickly as possible, as quickly as reasonably possible. Now, the two could have been catered for by issuing a process letter at the end of phase 1, recognising that the process letter would make available the knowledge that government funding was available to cure the problems I've identified. And that process letter would have ultimately not taken any longer to deal with than the process that was adopted. Now, instead of that, there was then the selective engagement point. I showed you yesterday the advice from Lazards at the end of phase 1, saying, look, significant collateral requirement is necessary to get this across the ground. That was the tab 36 document in the supplemental bundle I took you to. There was then the interaction between Lazards, the JEAs, and Octopus that I went through yesterday. I think I didn't take you yesterday to an email from Ms. Kotzeva of Lazard. That's supplemental bundle 3, tab 39, page 603.
Sorry, could you just give me that reference again?
Supplemental bundle, volume 3, tab 39, page 603.
Thank you.
This is from Ms. Kotzeva to the JEAs, essentially. She had a meeting that day, Friday the 13th of May, with Stuart, who I anticipate is Stuart Jackson, somebody called Rory and Greg. Very serious in the whole book, plus additional aspects, unlikely to slice the book. So this is confirming that Octopus are very serious and want to buy the whole business. 5 or so bullet points down, she had given them the date for the Secretary of State meeting, so they are pre-warned. They then said they seem keen to talk to Treasury on after the possible re-risk. Noted they expect it will take more than 1 month to hedge the book, and this is therefore likely to move to post-October. I said they should talk to us, not go direct. So discussions are taking place, and this is, I think, 2 days before the bid goes in, or possibly the day before the bid goes in. Octopus are in a position when they're trying to envisage A, meeting the Secretary of State, and B, talking to the Treasury on what could be available by way of government funding. What is the art of the possible regarding the risk? Now, the risk there being unhedged exposure and significant debt. So the analysis, therefore, with respect by the Divisional Court at paragraph 62 that we looked at yesterday, explaining why, in the Divisional Court's view, Octopus wasn't told anything more meaningful than anyone else, we say, I'm afraid, is demonstrably wrong, because Octopus, by this stage, had been reassured that government support would be provided. They'd expressed concern about working capital requirements and hedging, but effectively being told they don't need to worry about that. Put in a zero bid and we'll make sure that gets delivered. They had been told, tellingly, that whatever bid they put in at this stage would be renegotiated in due course. And they had been told that meetings with the Treasury, whilst not directly, communication with the Treasury would be indirectly achieved to see what was the art of the possible. And if we look, please, in the third bundle again, tab 40, there's a further email from Mr. Baird of Octopus to Mr. Quantock, updating Mr. Quantock on the meeting that had taken place with Luba Kotseva of Lazard. He says, Luba had a flash of the red carpet treatment with a tour of the building, etc. Second paragraph down by the second hole punch. She explained that access to stakeholders, including government, can be made available for structuring conversations. And separately, Greg is leaping on to how to exploit Octopus's relationship to maximise OE edge. Luba said Greg would see Quasi in slots held on the 23rd of May. That's the Secretary of State. So this is a bidder that is moving forward in the confident expectation that government support will be delivered. Now, in contrast, as the Divisional Court found, British Gas's proposal was tentatively expressed to recognise the need for government support, but it was anticipated that the government would provide a proposal as to what the support was, or at least that support would be available. It had to be an open, transparent auction process for the government funding, not for the private sale. And that was the problem here. Now, with respect, contrary to the finding at paragraph 63, the material communications that I've identified with Octopus and with Tudor were significantly more than was given to anyone else, and certainly more than was given to British Gas and E.ON, who are the appellants before this court.
So are you asking us to set aside that finding of fact?
Well, it's an evaluation from primary facts, my lord, so yes, because it's demonstrably wrong, because...
Well, just say yes on the basis that it's irrational and demonstrably wrong. That's all I need. Thank you.
My lord, yes. And similarly, with the greatest respect, 64 Roman 4 suggests that the height of our submission was Octopus was the only entity which put in a bid assuming such a significant level of government funding. The point we were making there is, well, it's telling, with respect, that when you have Octopus that is putting in a bid that relies upon a very, very high, substantial government intervention in the market, and it's the only one to do so. In contrast, Tulip is saying, well, we don't think government funding is available, so this doesn't work for us. And British Gas, you know, they assumed that a government proposal of some sort would be necessary, but it was never forthcoming. All of this problem with different bidders trying to second guess what the funding would be is indicative of a process that is, with respect, flawed. Now, the suggestion in 64.4 that somehow Octopus had identified a market value which had eluded all of the other significant players in this market, we say, with respect, is not a credible conclusion. The thing that made Octopus's offer bid different was not the underlying valuation of the business. It was the countenancing a very significant level of government support. And when I showed you the confidential figure for British Gas earlier from the initial market-driven bidding process from Bulb Management, that figure was very significantly higher than the final amount paid by Octopus by way of an equity injection into the company.
What do you draw from that? I mean, they're different. That's apples and pears, isn't it?
My lord, those are the bottom line evaluations of the value of the company.
Different times.
But no, assuming no debt and no problem with working capital.
It's also pre-Ukraine, isn't it?
It is pre-Ukraine, but the hedging problem was already in existence in November 2021, 3 months before Ukraine. True it is that wholesale volatility was worsened by the Ukrainian invasion, but it was worsened, it didn't dramatically change. And the wholesale prices had been extremely high, which had driven the Bulb insolvency. So in terms of what is the bottom line valuation of this business, you have the two figures, confidentially, that I'm not going to say, but they are different. Both of them, and this is why it is apples with apples, both of them were premised on there being no debt, it being a debt-free company, and the hedging issue having been catered. So the position, with respect, we end up with, the position that evolved with phase 2 was as follows. The Octopus had initially dropped out without making a phase 1 bid, but was induced to re-enter the bidding process and told that the government would be delivered and any form of positive bid would be a bid worth making. They'd been lined up to have indirect communications with the Treasury regarding the art of the possible. There was then a period, see paragraph 76 to 81 of the judgment, post the phase 2 bid, where Octopus actually had very substantial negotiations as to the mechanics of the support. So that is not, with respect, the way of doing subsidy control either, because you're meant to be encouraging people to bid for the least amount of taxpayer money possible. Instead, what you have is a selection of the beneficiary and then discussions between the beneficiary and the government as to how much they require. That naturally is going to be...
Is it your case that an auction model is the only model that will satisfy the requirements of the TCA?
On the facts of this case, in circumstances where you've got essentially a necessarily state-sponsored funding arrangement in order to ensure the sale of a company from private ownership back into private ownership, and it never went into public ownership. Where you are trying to determine what is the least amount of subsidy that will achieve the legitimate objective of ensuring that those customers carry on receiving their energy supplies, there has to be a bidding process to work out what is the lowest form of taxpayer money that can be considered.
If it was a very straightforward subsidy and all you were looking for was a number of cash, I can see that, but this was a very complex situation. There are many different ways of dealing with the debt and the absence of hedging for the winter period. At least I think there are. And a model where you say to everybody, I'm willing to, and valuing the cost of these different sorts of support is not straightforward, because money is money, but any form of guarantee or sophisticated arrangement, the value will depend on predictions as to how it will turn out in the end. So an auction would be quite difficult to arrange, wouldn't it? Isn't it enough just to say, look, we know these problems have to be resolved. Come and talk to us. We're willing to do it. Come and talk to us about how you think it could work. And this is the sort of thing that can only be worked out in negotiations.
I apologise, I misunderstood. Subsidy auction simply means a process by which there is a freely competitive process by which the level of government funding is identified. I don't necessarily mean that.
But the level, that's really my point, is that level of government funding being identified is fine when it's, 100 million or a billion. But not all subsidies are of that sort.
But the subsidies here are, with respect, essentially financial, because the level of support needed to provide hedging cover is capable of being reduced to a figure, as the WAMA confirms. It was an amount of money that was a commitment to meet the wholesale price, but then a requirement to pay back at a different lower price at the time. You've got the equity injection, which is a figure, and you've got the buyer equity injection, which is a figure. So all of those figures are capable of being reduced.
So the auction should have said, we will inject this much equity and we will provide a hedge on these terms.
Well, not with respect, my lord, I don't think so in the first instance, because it was sufficient simply to say that government funding will be provided to cover the two obstacles to a transaction that I've identified, and then to leave the parties to propose both transaction structures and the amounts that they were after. The government would then have assessed those competing offers of government funding in order to land on a solution, comparing the different bids and their different structures and saying which is the one that actually requires less call on taxpayer money.
Your complaint a moment ago was the negotiating with Octopus about the level of funding once it was the only bid left in town. I think you said the proper approach should have been to offer the same to other bidders.
No, with my lord, if that's the way it came across, I'm sorry.
Sorry, let me rephrase the question. I think what you said was they selected Octopus and then negotiated.
Yes.
But that's not quite right, is it? Octopus was the last man standing, and then they negotiated.
Octopus was the only person that put in a phase 2 bid.
Yes.
And that was predicated on a very substantial amount of government funding being made available. British Gas pulled out because they didn't have the assurance that that government funding would be made available, and so did Tulip. Tulip, when it withdrew, expressly said, we've seen no appetite for the government to fund this. That was the 16th of June email that I took the court to yesterday.
But they went back to Tulip, didn't they?
They went back to Tulip and then offered a specific structure on the 28th of June. This is covered, I think, in paragraph 72 of the judgment. Perhaps 71. Sorry.
70, I think.
70, sorry. Yes, thank you, 70. So 70 subparagraph Roman 4, Tulip contacted Lazard to inform them following extensive work. We don't think it's in our best interests. We believe an ongoing HMG participation in the business is likely to be essential to help through the short to medium term uncertainty. However, it has not been clear to us if HMG has appetite for such a role. So that was deterring them putting in a phase 2 bid. And if HMG had said, we're going to solve these two problems by providing government support to the extent that we consider is necessary to deal with this, we invite you to say what transaction structure you will adopt and how much government funding you therefore require. Everyone could then have bid for that on a level playing field basis. Instead, what you then get, see Roman 5 and Roman 6, is Lazard initially proposing a period of joint ownership and then saying, does the following proposal, which was essentially the Octopus structure, deal with your concerns? Now, true it is that after all that, Tulip, for reasons unique to Tulip that I don't need to go into because it's still a confidential party, Tulip decided not to push ahead even in the knowledge that that structure was potentially available, but that offer was never made available either to E.ON or to British Gas. So Octopus was the last person standing only on the basis that nobody else had been given the assurances Octopus had other than Tulip, and Tulip decided for reasons best known to itself not to put in a bid.
Just remind me, I know I should be on top of this. What do you say was the offer, the small o, that had been made to Octopus?
The Octopus offer is essentially government will be delivered. You can put in a bid.
So the what will be delivered?
Government support will be delivered.
But
to deal with the working capital issue. Because
government support will be delivered. But I mean, that's very vague. You see at 61.5 a reference to some kind of funding support. Does it go any further than that?
Well, if we go back perhaps to the Quantip email, which is in Supplemental Bundle 3, tab 38, page 601.
Yes.
Seven or so bullet points down, it said that if we are over zero, then we would get into the next phase. Brackets, this ignores working capital, cash-free, debt-free. That's being told effectively, you stick in a bid at zero, or £1, and everything else, that will be fine.
To get into the next phase.
To get into the next phase, admittedly. But it's being told you don't have to worry about the debt position, you don't have to worry about the working capital position. The inference that's been drawn from that is that offers over £1 with a guarantee from government on the working capital. So that is what Mr. Quantock has taken from the communication he's had with Lazard. He's also told all government stakeholders are lined up and agree to this timetable. Now, the Divisional Court saw that as a timetable issue. I'd respectfully suggest that government stakeholders are lined up, i.e. they've thought about the guarantee from the government on working capital, and it's a concrete thing, it's not a potential thing, whereas everyone else thought it was a potential thing. So he really pushed on this because nobody else, understandably, thought that the government had committed to this as a proposition. He really pushed on this. Who is it? Is it the department or HMT? But they reiterated that government would be delivered. Now, in context, that's nothing to do with a timetable. That's to do with the government sorting out the problem, which is cash-free, debt-free commitment on working capital. He says, I'm struggling with this personally, unless they've already agreed parameters with them based on what they've got and are going through to the second phase. Seem to imply that further diligence and negotiation will be done post-binding. Again, not quite sure how you can do that, i.e. the details of how much funding will be provided are a matter for negotiation once you've selected the bidder. And he says, well, I'm not sure how you can do that. He said, speed and execution is the core of any offer. And he then said, I sense there isn't really a proper process here. They're playing it by ear and seeing if they can get a deal that works. That, with respect, is the antithesis of an open, non-discriminatory, competitive process in order to select the minimum amount of taxpayer funding that is going to be needed to get this transaction across the line. My Lords, I'm sorry I've shot beyond my anticipated slot by 15 minutes. Unless you have any further questions for me, I will hand over to Mr. Perez to deal with the rest of round 3.
Would now be a good time for the translators' break. This is a natural break.
If the transcriber would like a break, would you like a break?
Yes, please.
Okay, have a 5-minute break. That means 5 minutes.
Court, rise the table.
Some furniture rearranged.
That's all. And we'll skip it time to rearrange the match.
There's just one microphone.
phone. Is there one by you? Can you move?
I thought there was.
Can you move that by you? And
Yes, there was a little one and a little tripod
yeah, I
at some
don't
point, but it seems to have
yeah.
disappeared.
So when you're changing, so when you and then later on we can
Will
move
it-
that back over. If you don't mind, thank you.
No, not at all. Does that work for you?
That should be fine as long as I can hear you.
Yeah.
Right, thank you so much.
Yes, it's fine. You have. Yeah, fine.
They're obviously a bit traumatized with what exactly we have in mind. I mean, the truth is, it's not for me to work out on compliance process. All we can really say is, this is what they should have done. What they did not stand.
Yeah.
What the actual process would be for them to determine as long as they were compliant with the non-discriminatory. In terms of not having any bidding process, essentially they need to do a bidding process. It doesn't need to be a formal auction with everyone in the room.
It needs to be a process of getting bids in and having a look at it. I mean, there's no doubt that evaluating deciding which one was best would be quite a tricky exercise on which views might be different.
Some people may, for example, have said, I will shove it through.
Yeah.
Assuming risk of hedging themselves, like having capital. But then commensurately put in a lower equity injection.
Absolutely.
And you have to compare and contrast.
Yes, I mean, it was more going to be a position where I didn't some very simple transactions of say that, where it's simply a figure sort of. It's never going to be.
I mean, it's amazing.
Yeah.
Court rise if able.
My Lord, obviously I'm conscious of the time. I hope your Lordship will forgive me if I try to make as much progress as fast as I can. We'll see how we get on in terms of timing. I have two tasks. One is really to answer the court's question from yesterday about how does the concept of open, transparent, non-discriminatory process feed into the Article 366 principles. So that's going to be the first part of my submission. And then second, as a separate matter, deal with something that we really haven't looked at all to date, but which is part of our, is a ground of appeal, which is what we say is the Divisional Court's errors in relation to the analysis of the subsidy as a restructuring subsidy. It's a particular set of rules that prohibit restructuring subsidy subject to closely defined provisions. And I will need a little bit of time just to show you what the issues are. We haven't yet touched on that at all. So starting off with the sort of legal context of open, transparent and non-discriminatory, it's perhaps helpful to start by looking at how the Secretary of State dealt with this in the subsidy control assessment, which is in the third supplementary volume at tab 44. We've been to this already, but this is just to remind your Lordships how the assessment is structured. Your Lordships will see, your Lordships are there.
Can you give me the page number?
Yes, page 600 starts at 618, and I'm going to pick it up at 619.
Thank you.
And your Lordships will see a heading restructuring subsidy, and then there's an analysis of the various elements of the transaction, I'll come back to that later when I deal with restructuring the subsidy. But if your lordships then go on to page 622, under the heading at the bottom, potential subsidy to orchid, that's octopus, the question there being asked is, have we, by entering into this transaction, not just subsidised hive comb bulb, but have we also given a subsidy to octopus? So that's the question being asked at the bottom, and then at the 623, the deal is basically summarised, and then the analysis starts in the second paragraph immediately under the bullet points, where it is said that the Draft Subsidy Control Act guidance, paragraph 691, and EU state aid law indicate that public authorities will be able to show that there is no subsidy to the buyer where an open and competitive process has been followed. And then it says, as Octopus's bid has been proposed following such an open, non-discriminatory and competitive sales process, there is no subsidy to Orchid Octopus as the buyer. So that's the first way in which the claim that an open, non-discriminatory and competitive sales process fits into the Article 366 analysis, is to say that in fact we don't need to look at Article 306 principles in relation to octopus because there is no subsidy to octopus. So that's the first part of the Secretary of State's analysis. Then, and we've been to this before, so I can hopefully deal with it quite quickly. If you go on, there's then a table starting at 627, which deals with the specific subsidy control principles in the left-hand column, numbered A to F, and then the analysis of the answer to why the Secretary of State considers that those principles were satisfied in relation to what is admittedly a subsidy to hive code. And if I can just draw your Lordship's attention, is where the open and transparent and non-discriminatory principle fits in there. At page 628, where it's considering principle B, your Lordships will see that it starts off by saying the competitive nature of the extensive M&A process demonstrates that the subsidy is proportionate and limited to what is necessary to achieve the objective. So that's a foundation claim of the Secretary of State's view that principle B was satisfied. And then in relation to principle E, at 633, which includes satisfied that the objective cannot be achieved through less distortive means, your Lordship will see the second bullet point right at the bottom of the page, again refers to an open, transparent and competitive M&A process. And that was one of the bases on which the Secretary of State found that the subsidy that he was admittedly offering to Bulb was the least distortive possible, thereby satisfying principle E. Now, we say that in accepting the importance of the open and transparent competitive criterion, the Secretary of State was right. Running an open, competitive and transparent process was required as a matter of law in a situation like this. That is our claim. It wouldn't be required necessarily in every single situation. I'll come on to what the Commission guidelines and so on say, but making clear to the Court what proposition I'm advancing. It's not necessarily true that in every single situation where there's a state sale or effectively a state sale of an asset or purchase of services, entering into a transaction of a kind analogous to this, that it's necessary to run an open, transparent and competitive process in order to demonstrate absence of subsidy or minimum subsidy, as the case may be. There are cases where they're going to be a whole set of perfectly reliable benchmark, equivalent transactions, against which you can easily check whether the deal you have done is on market terms, given a widespread amount of data available in the market about what the price of such transactions would normally be. That may happen, but that is obviously not this case, because on any view, the transaction that was being entered into in this case was not only an extremely large amount of money, but also a transaction that was unique. There was simply no appropriate market comparator that offered any form of safe cross-check which enabled you to reach the threshold of being able to show either no subsidy or minimum subsidy, as the case may be. Now, I'm going to start with EU law on this, not because we've forgotten about Brexit, but because it's sensible to start with it in understanding the background to the trade cooperation agreement provisions and to the domestic guidance, and of course because it happens to represent the law of the other part of the trade cooperation agreement. And the law is helpfully summarised in the Commission notice on the notion of aid, which is at volume 8 of the authoritative bundle at tab 107. At page 4082 of that bundle.
Thank you.
And if I can pick that notice up at paragraph 83, which I think is at 4100.
So what is this note?
This is a notice issued by the Commission. As your Lordships may remember from looking at cases on EU law over the years, in many fields the Commission will issue notices explaining what it takes the law on a particular subject to be. There are plenty of notices in the competition field where the Commission does this. There are also plenty of notices in the state aid law field.
Which paragraph did you want to go to?
So if you pick it up from paragraph 83, under the heading Establishing Compliance with Market Conditions on page 4100. And the MEO test is the Market Economic Operator test, which is in the jargon that we now use in the UK is the Commercial Market Operator test, effectively saying that are you satisfied that the state is acting here not as a subsidiser, but is it just entering into an ordinary commercial transaction on ordinary terms, so that there is no subsidy? So that's the MEO test. So when applying the MEO test, it is useful to distinguish in situations where the transactions compliant with market conditions can be directly established through transaction-specific market data, and situations in which, due to the absence of such data, the transactions compliant with market conditions fall to be assessed on the basis of other available methods. If you want looking at that paragraph, what one sees is that if you've got what they call transaction-specific market data, I'll go on in a second to show you what that means, that's how you do it, but in the absence of those data, there are other available methods.
That's just what it says. So
yes, indeed.
If you're short of time, you need to read it and then tell us what it says.
So over the page,
Yep.
What are transaction-specific market information? You get that at 84. And the first little Roman one is pari passu transactions. That's a situation where typically where a public sector invests in a particular company. And it says, well, this is a market investment because, hey, look, there are a whole lot of private investors that have invested on exactly the same terms. So that's the pari passu test. And then what concerns us, little Roman 2, where it concerns the sale and purchase of assets, goods and services or other comparable transactions, and we would say this is effectively a comparable transaction, carried out through a competitive, transparent, non-discriminatory and unconditional tender procedure. So that's when you get what the Commission calls transaction-specific market data. And that is the default method. If you've got those data, that is how you do it. And then
for determining whether it
is a subsidy, and I just go on, it's also what you would use when you're determining whether it's minimum subsidy as well. But this notice is concentrating actually more, it's the notion of aid, it's whether there is a subsidy at all. And I could skip over little 86 to 88 because that deals with pari passu transactions, and then 89 to 93. I would just invite the court just to read that rather than me reading it out. 92 to
Very well.
89 to 93. if I just pull a couple of points out of that. First of all, this is obviously, as I've made clear, this is the Commission speaking. But your Lordships will see from footnote 146 that the Commission cites authorities of the CJEU. I'm not going to take your Lordships to those authorities, although one of them, Blunt Burgenland, was in fact cited before the Divisional Court and it mentions it in its judgment. But one will see that this is backed up by European Court jurisprudence. Second point, which really emerges both from that footnote and from paragraph 89, is how this relates to the question of whether public procurement exercise has been carried out. And essentially, the Commission points to that and says, well, if that is what, if a procedure in accordance with public procurement rules is carried out, that's very good, but it's not absolutely necessary. Indeed, that's contained in the end of that footnote, because it's saying that when the courts talk about an open, transparent procedure, they're not necessarily meaning one that is fully in accordance with the public procurement rules. The key points, though, are 91 and 92. It's the Commission's emphasis on accessibility of information at each stage of the process. Clarity of the selection award criteria are what it says crucial elements for transparent selection procedure. And then 92, non-discriminatory treatment of all bidders at all stages of procedures, objective selection and award criteria specified in advance are all indispensable conditions.
Bidders is the word you use.
Yes, bidders. Well, I mean, it's covering all sorts of types of process, of participants in the process. So that's what the Commission considers to be necessary. And for the reasons Mr. Beale has explained, we say in this case, those conditions were not met. And it's worth noting in this context that when the Commission is confronted with the claim that open, transparent procedure has been used, the Commission doesn't just accept that at face value. It looks quite carefully in its decisions at whether that process was in fact followed. And though I don't need to take your Lordships to it, we cite a case which shows how that is done, which is the Greek state aid decision at tab 79 of the authorities bundle at 2858. And I invite your Lordships, when you have a moment of leisure, just to have a quick look at how the Commission did that. It looks quite carefully at whether the Greek authorities claim that such a process had been followed was in fact correct. Essentially, it pokes the process quite hard to ensure that it was in fact open, transparent and non-discriminatory. Now I'll come to the Bayes guidance.
Sorry, come to the... I just didn't hear.
I'm now coming to the Bayes guidance.
A Bayes guidance?
Yes, the Bayes guidance. Yep. Which is at tab 102 of the authorities bundle, starting at page 3763. But I am going to, as your Lordships will see, quite a long document, and I am going to start at 3942. Just to put this in context for your Lordships, this is the final guidance, and in fact it wasn't there when the decision was taken. The Secretary of State is referring to an earlier version of draft guidance, which, save for one page, which I will come to in a moment, is not in the bundle, but the parties have agreed effectively that the final guidance sufficiently reflects the draft guidance for it to be worth just looking at the final guidance. And that is what is in the bundle, save for one wrinkle, which I will come to in a moment. And as your Lordship saw a few minutes ago, this is the Secretary of State said that he was following the draft guidance. Now, this part of the guidance is starting at paragraph 15.66 on page 3942. Your Lordships will see this is under a heading of tendered sale and purchase of goods and services. Now, again, this isn't quite a tendered sale of goods or services, but we say, and I don't think there's any serious dispute about it, indeed the Secretary of State has taken the view that it's closely analogous to such a sale or purchase of goods and services. Economically, it's the same thing. So 15.66 sets out the requirements when the technique is used. And you will see in the bullet points that aims at equal and non-discriminative treatment to all bidders, open and transparent, carried out in a proportionate manner. And all of that echoes, no doubt consciously, the EU language that one will have seen in the notice of, on the notion of state aid. And there's certainly no attempt to disabuse the target audience, most of which would have been people who were rather familiar with operating EU state aid rules, that something different was intended here. So one can assume that it's getting at the same thing. 15.68 then deals with the specific situation where there's only one bid has been received in a tender process. And there it is said it is key, essential, one might say, that the public authorities are able to demonstrate that the process made it possible for more than one tenderer to submit a bid, and that there are adequate safeguards in place to ensure genuine and effective competition in the procurement process. And then it said public authorities may also seek to verify that the outcome corresponds to market price using additional analysis. So that suggests that where you've only got one bid in a tender process, you run a what you say is a genuine and effective competition. You might also wish to sort of cross-check that against benchmarking. And of course, in this case, that is what the Secretary of State did attempt to do, because he did have a look at certain benchmarks. Your Lordships will have seen that. And your Lordship will also have seen that below there was a certain amount of discussion about whether those benchmarks were adequate. It's not a point we're pursuing here. But there was a sort of cross-check. But we say it's clear from the guidance that in that situation, the key point is, have you had a genuine and effective competition, and that the benchmarks play at best only an ancillary role. Now, this is the point at which there might be a slight point taken about the terms of the draft guidance. So I'll just have a quick look at that. That's at the preceding tab, page 3762. It's an extract from the draft guidance, paragraph 693, and the Lordships will see that that's the equivalent paragraph, but that the final sentence is slightly different in that it says alternative rather than also may verify. So it might be suggested that in the draft guidance, it was being suggested that this was an alternative technique, as an alternative to satisfying yourself that you had a genuine and effective competition. If that is suggested, that we say that that is a misreading, and one can see that because if one goes up to the second line of that paragraph, you still have the statement that it is key that the public authorities are able to demonstrate that the process made it possible. So we say one has to read alternatively as perhaps slightly loose drafting, and perhaps corrected in the final version. And what was really meant here was this might be a way of supplementing an analysis based on the existence of a genuine, open and competitive process. Yes. My learned friend, yes, also points out so that public authorities may also use competitive processes to give financial assistance to certain enterprises on terms that are not commercial. So this is the subsidy competition point. And that point then makes the point that what a competition will do is not eliminate the presence of a subsidy, but it enables you to demonstrate that some of the principles are made out. So that's the point I was making about the concept of open and transparent procedure.
Sorry, I haven't understood the point you've given by your...
Yeah, sorry, Mr. Beale...
What the point's relation to.
Yeah, Mr. Beale made that if Mr. Beale suggested, and it seemed to me to be a good idea, while we were on page 3762, the draft guidance, just to have a look at page 690, paragraph 695, which is immediately below the one I took your Lordships to, and that makes the point about subsidy competitions in a situation where there is subsidy, and the question is how much is it going to be, and then running a competition enables the authorities to say, well, yes, we are satisfied that the minimum subsidy was given.
But hang on, well, why are we looking at that in... Oh, I see.
Just because we're on the page, I think.
Yes, but it's equally in the final version.
It's equally in the final version, but Mr. Beale suggested...
No, fair enough. I'm just trying to see how it fits it in.
Yes.
Okay, thank you.
Yes, indeed, the point is made at...
But there's no real difference between 695
and 15.71. Yes, it makes exactly the same point. Yeah. Yeah. Yes, and then...
Sorry, and can I just understand 1569,
yes.
which is identical in the draft, regardless, I don't quite understand what that means, regardless of what?
I think regardless of
1568.
Of 1568, yes.
Public authorities may seek to
May seek
undertake
further
further
analysis.
analysis. But haven't they already just said that?
Yes.
Public authorities, is this just repetitive?
It's somewhat repetitive, yes.
Yes, I see.
I mean, obviously, this is not a statute or...
No, but they are important documents.
Yeah, indeed.
It's important that they be clearly drafted.
Indeed, and the function of the guidance...
No, it's fine.
It's statutory guidance. There's statutory provision for it under the Subsidy Control Act. So it's certainly important guidance, and indeed...
I just wasn't clear whether that was saying anything different than the final sentence of 1568.
No.
Right.
Yes, and then we've looked at 15.71 already. 15.72 deals with pari passu, and then if I can just go on to 15.75, it says public authorities may also adopt other methods of economic analysis that are based on objective and reliable data in order to assess compliance with the commercial market operator principle. Such methodologies may be used where direct evidence relating to the financial assistance is insufficient in demonstrating compliance. Now, the direct evidence is what we've been looking at, the open competitive tender. And it then says when that is insufficient, you can use these other methods, and you will see some of the methods that are referred to are benchmarking analysis and profitability analysis. I don't need to go into that. But that's therefore the structure of the Bayes guidance, which is that the, if you like, the open, transparent and non-discriminatory process is the gold standard way of doing it. And is the one that you should adopt where you can. Now, of course, the Bayes guidance is to the Subsidy Control Act 2022, not technically to the principles under the TCA. But I don't think there's any suggestion that in any material respect, there's any difference between the Subsidy Control Act approach and the Trading Cooperation Act approach. And indeed, since we're told by the Secretary of State at paragraph 9 of the skeleton that it would be surprising if there were any inconsistency between the Subsidy Control Act and the Trading Cooperation Act requirements, given that Parliament intended to implement the TCA. Now, if I can just look at how the Divisional Court approached this. This is at paragraph 249 of its judgment in the core bundle, tab 7, at page 166. And your lordship...
Which page did you say?
Page 166, paragraph 247 to 9.
Yeah.
And at paragraph 249, it actually looks at the Commission notice on the notion of state aid, what I've just taken to you, and it's recorded that I made submissions to them on that. And then the Divisional Court sets that out. Now, our comment on that paragraph is that the Divisional Court doesn't get the emphasis quite right here, because what the Divisional Court does is it says compliance with the MEO principle can be established if the transaction is carried on through a competitive procedure. And then it goes on to say, however, it is clear that that is not the only means of establishing compliance with market conditions. Now, we say that rather misses what we say is an important feature of the notice, which is that, if you like, the open and transparent procedure is the default method. It's only in the absence of such data, your lordships will remember the wording in I think it's paragraph 92 of the notice, that you look at those other methods. So the emphasis here is not quite right. In fact, that is the default method. It's the method that is expected as a matter of EU law. certainly in a case such as this, where you wouldn't, there aren't large numbers of other equivalent transactions lying around, which you can readily easily look at to see whether the transaction that you have got involves subsidy or involves more than the minimum amount of subsidy. There isn't an easy available cross-check. In some sectors, in fact, there's a case that the government cites that we will say as an example of those sectors. Some sectors such as airports giving aid to airlines, a very frequent topic of EU state aid, one is replete with market transactions because airports do deals with airlines all the time. There's endless comparators. So if there's a suggestion that a particular transaction involves state aid because it's unduly generous to the airline, it's relatively easy to find other transactions to cross-check that against. And therefore you don't really need a tender. But obviously that's a very, very different case from the present one.
Does that point go anywhere? That if there's an error in 249, does it go anywhere? Do you challenge, for example, 247, where they say that the purpose of the process is to provide an evidential basis for the 2 points there mentioned?
Yes, I mean it slightly depends on what the Divisional Court actually means by that. I think what we are concerned is that the Divisional Court seem to think that it's effectively optional. There are other ways in which you would do this. And as I said, our case is that certainly for this particular type of transaction, a unique, very large transaction, there is in fact, as a matter of law, no other available way of doing this lawfully, because anything else, there simply isn't going to be any other way in the market of establishing a reliable basis of comparison. And we say that we can really deduce that from what the Commission says is notional state aid and from the Bayes guidance. This is the default method, the best gold standard way of doing this. Both the Bayes guidance and the EU notice make this point is by open and transparent procedure, or of course pari passu, that was an alternative in this case. That's the best way of doing it. And we would say in a case like this, where there's no other reliable way of doing it hanging around, distinct from my example of airports, giving state-owned airports, giving sweetheart deals to airlines, where it's replete with comparators. It's very easy to find comparators. No comparators here. I mean, the Secretary of State did a benchmarking exercise, sort of trying to find the best comparators that they could, but I don't think the Secretary of State suggests that that was on itself any form of reliable exercise, say with more than a cross-check on the transaction. It certainly wouldn't have been a standalone basis for a conclusion that there was no subsidy or minimum subsidy, absent an open competitive process. Now, the difference between us is the Secretary of State says there was one and we say there wasn't. But what I'm inviting your Lordship to be somewhat cautious about is what we say may be a suggestion of the Divisional Court, that, well, it didn't really matter whether there was one or not, it's only evidential, could have been done another way. Therefore, and the problem with that is you then say, well, if the Secretary of State is wrong about it being an open and etc. process, does it matter? And the danger is you may end up with the conclusion that it doesn't, whereas we would say it very much does matter, because it's just an essential part of the reasoning in a case such as this. So I'm sort of very conscious of time. I've got to cover restructuring subsidies. I will try and do it as quickly as I can. Your Lordships may end up having to sit slightly later with a combination of given the breaks. I'll try and do it as quickly as I can.
Having to do anything.
Maybe invite. Sorry, I put that in. Your Lordship is right. We may have to invite your Lordships to sit a little bit later. I'm trying to do this as fast as I can, but I do need to cover restructuring because it is a separate point. It's one that we haven't covered before. If we go back to the subsidy control assessment, just to remind ourselves what the Secretary of State's reasoning here was, that's at supplementary bundle 44, page 3682. So the Secretary of State, page 619, Secretary of State recognises that there's restructuring subsidy. That's evident from the heading at the top of page 619. And then there's a long discussion, which your lordships are familiar with, about what that restructuring subsidy amounts to. And then the question of how the prohibition on restructuring subsidy, which I'll come to in a moment, is dealt with, starts at 639.
639.
639. So the Secretary of State introduces the analysis under the subsidy control analysis by saying, first of all, in Article 346.3 TCA situation, the conditions attaching to rescue restructuring subsidy do not apply. So that's his opening gambit. And your lordships may note that page 637, a couple of pages before, in a somewhat different context, but this is what's cross-referred to, the Secretary of State considers whether Article 346.3, this is the national or global economic emergency provision, which I'll come to in a moment, applies, and he is satisfied that it does. So if you turn back to 639, his first line, his first proposition is, well, this is an Article 346.3 situation, so we don't need to worry about the prohibition on restructuring subsidies. So that's the first point I have to deal with. The second point I have to deal with is his analysis that the restructuring conditions are met, because the point about Article 367 is that it prohibits restructuring subsidies, save for closely defined exceptions. And the particular exception that is the subject of debate is the Article 367, as we will see, in the case of certainly large enterprises, of which this is certainly one, it has as a condition for restructuring subsidy that the private sector should make a significant contribution to the restructuring, and that is dealt with in paragraph B of that analysis, where the Secretary of State considers whether it is a significant contribution. And I'll come back to that in a moment once I've shown your lordships what the law here is. So that's the subsidy control analysis. Starting off with Article 364.3. Now that is in your Trade and Cooperation Agreement, which is at tab 93 of Volume 8 of the Authorities Bundle at page 3682. So your lordships will see paragraph 3, subsidies that are granted on a temporary basis to respond to a national or global economic emergency shall be targeted, proportionate and effective. And then Article 367, as well as 374, which is remedial measures, do not apply to such subsidies. So this is an exception to the general prohibition, are all the general prohibitions in Article 367. So what do we say about that? Well, what we don't say, we don't deny that there was a national or global emergency caused by the Russian invasion of Ukraine and its effect on energy prices. That's not the dispute. The dispute is whether this particular subsidy can be said to be a response to that emergency, or perhaps more generally, whether a subsidy that aims to rescue or restructure a particular business, that when there is an emergency, and because of its own particular vulnerabilities, gets into even more serious financial difficulty than it was already in, which is the position here, can be said to be a response to that emergency, in a context where its competitors do not need subsidy or help or get into financial difficulties requiring subsidy. And as Mr. Beale has explained yesterday and today, the problems with bulb well predated, indeed it went into SAR, well before the Russian invasion of Ukraine, and its vulnerability and problems stemmed from its buying very heavily on the spot market and failure adequately to hedge. And all of those, and indeed the process that we're looking at, had started before the Russian invasion of Ukraine. And we say it's simply not enough for Article 364(3) purposes to say that Bulb would, as from the Russian invasion of Ukraine on the 24th of February 2022, have been in quite such extreme financial difficulty had that emergency not arisen. And generally, that it is simply not enough to say that where a business falls over or gets into problems, or its problems get worse because of an emergency, that means that you can then freely give subsidies, restructuring subsidies to that business in reliance on Article 364(3). We say that is simply not right. And this, in such a situation, is not to be viewed as a response to the emergency. It's a response to the particular condition of that business, which happens to be somewhat exacerbated by an emergency. Now, what a response to an emergency would be a response aimed generally at the consequences of that emergency. And a sort of classic and obvious example, probably in the minds of the negotiators to this agreement, because it was very much going on at the time, is the government's response to the COVID emergency, which was to give a very generous subsidies to a very wide range of businesses affected by that emergency. That's the sort of thing, a general subsidy, or if you have some form of emergency that affects a particular sector in a very grave way, to give particular aid to that sector. And that could be said to be a response to the emergency. But just to focus on one particular business that was already in trouble, gone into SAR, before the emergency arose, cannot, and where the effect of the emergency was simply to make the problems that it faced worse, we say that cannot be a response to that emergency. And we say it's important to maintain that distinction, because otherwise a very wide door would be opened to either side of the Trading Cooperation Agreement, granting restructuring subsidies to businesses that could plausibly point to an emergency as one of the causes of their problems, or one of the causes of the extent of their problems, even in a situation where other businesses survive perfectly okay without such help. And of course, the context here is that rescue and restructuring subsidies are widely recognised as particularly distortive in their anti-competitive effects, because they weaken the disciplines of competition, they keep in business entities whose assets would be better deployed elsewhere, and they blunt the incentive of competitors to efficiency by creating moral hazard. And I won't take your lordships to it now, but for your lordships note, that is set out in the Commission guidelines on rescue and restructuring at paragraphs 6 and 9 at tab 106 of the authorities bundle, page 4056. And that is why you have a general prohibition of them in Article 367. They're recognised as particularly problematic.
There's a slight nuance here, though, isn't there? Because that's true if you're dealing with a failed business, generally. But in this context, the statute requires the company to put into SAR, the purpose of which is to preserve the business, essentially, either in the company as a going concern or by it being transferred to somebody else.
Yeah.
Because this is regarded as a business which simply cannot stop. There's too much prejudice to the customers. So that context does seem to me to have perhaps.
Well, you're certainly in a context, and of course one of the objectives of the SAR is to maintain supply of electricity at a low price. That's not quite the words used, but that's the gist of it. Absolutely. But of course, that's in the energy supply in the relevant energy acts. But of course, when you're thinking about this from a subsidy control perspective, as always, we've got sort of two separate regimes. The subsidy control perspective is that to restructuring a business which involves government subsidies, it wouldn't necessarily be the case in a routine energy administration, but in this case did. Such subsidy is particularly dangerous because it creates because the risk of moral hazard and the risk of a particular distortion in the market.
Sorry to interrupt. I thought you'd finished. Can I just ask you about 638? Because there it looks as if the government's looking at this as a national economic emergency because of the bulk customers being left without an energy supply. Is that a permissible construction or not?
Sorry, 638 of?
The supplementary bundle, the document you were taking us through.
Yes, that's the subject control decision. Yes, sorry.
You were taking us 639.
Yes, I'd rather foolishly put that to one side here up.
I mean, they may be right, they may be wrong, but I'm not sure that just saying it's a Ukraine invasion answers this specific point.
Yes. Yes, well, I mean, that's I mean, as I say, we don't dispute that there was an economic emergency, and as the assessment rightly notes, the Commission issued a temporary framework for state aid in response to that emergency, which allowed member states to issue a sort of cross-sectoral assistance to large numbers of undertakings to enable them to deal with the problem. So that, we say, it falls squarely within Article 3643. What we say doesn't, and this is where the analysis in the paper goes wrong, what we say it doesn't cover is a specific subsidy focused on one business, which just happens to have been adversely affected.
So your answer to my lord's point is that they were wrong.
It's where they went wrong, as I said at the outset, it isn't in identifying that there was an emergency.
I understood my lord's point to be that the Russian-Ukraine crisis had created a particular problem for bulb customers.
Well, it had a particular problem for bulb.
For bulb, well, all right, well,
and then,
well, but
looking at this bit, I mean, just on this, they're not looking at bulbs gone, etc. They're looking at the bulb's customers. And
yes.
The question I was asking was whether that is a national economic emergency within the relevant section or article for the purposes of permitting subsidy.
What it meant was that they, restructuring subsidy always has to have an objective which goes beyond just rescuing the business, because the subsidy control principles in 366 apply to restructuring subsidies, they don't apply to anything else. Just there's an extra set of conditions on restructuring subsidy. So what that enabled, the fact that if this business got into problems, there would be a serious risk to customers, was properly addressed as an equity rationale for subsidy. So that's where that fits into the analysis. What it doesn't enable the government to say is because this particular business has got into trouble, we are able to do anything which is needed under cover of 364.
But that isn't what they're saying. They're saying it's not just the fact this business has got into trouble, it's the fact that 1.4 million customers will be without electricity.
Okay. Well, that's the effect of the emergency. Well, it is, I mean, the reason why those customers, to go back to the point I was making earlier, the reason why those customers are at risk of their supplies being affected is not, it's only indirectly, and it's only at the very highest you can put it, that is only one of the causes of that, is the emergency, because bulb was already in difficulty. It was in problems before, so the problems of securing supply to consumers, the possibility that consumers might be left without any electricity, was a problem that was there on the 23rd of February, the day before the Russian invasion. It wasn't a problem. It wasn't a problem that was only caused by that. So, to the extent that the government is saying that that is only we're dealing with this particular, we're aiming at this particular problem, we're aiming to resolve this particular problem, which we say is a response to the emergency. Well, again, the answer is, well, that problem wasn't, it's only, the very most you can say is that the emergency made that problem a bit worse. The problem was already there. So how is what you're doing to assist them a response to the emergency?
It's shown this morning from around March or April, where the analysis was carried out that as a result of the Russian invasion of Ukraine, it now became clear that there would have to be substantial government support, whereas before that it may not have been so clear. So the reason for the subsidy was precisely because of the invasion of Ukraine. To protect the customers.
Well, I mean, that's right. I mean, yeah. I mean, the fact was, in terms of customers, that while the business was in it, basically, while the business was in administration under the SAR regime, it could carry on that way. It was getting government support, and we say that was, you know, the rescue aid that it was getting. We've had no problem with the rescue aid that it was getting. It would carry on getting that. And that was the thing that dealt with the position of customers.
Well, that's a
possibility of ongoing government
different point.
Yes, I mean to the extent that the government was saying, well, we need to give this very large subsidy at this particular moment because we're concerned about the position of customers. Well, the answer to that is the position of customers was already being protected by the administration, the government ongoing support that was being given under that. Now, of course, we perfectly accept that the government, quite understandably, and the JEAs wanted to find a more permanent solution. But to say that that was a response to an emergency, finding that permanent solution, we say goes too far in a situation where the electricity supply to customers was happening and could have happened for, you know, an indefinite period.
Yeah,
we're not saying that would have been a desirable outcome, but it was certainly
the emergency
possible.
only justifies the rescue subsidy.
Yes.
Okay.
Yeah.
I can't remember when your hard cut-off.
Yes. I'd need to actually deal with the restructuring provision itself.
Well, I dare say you do, but I just want to know when is your hard cut-off?
I will. Well, hard cut-off is supposed to be now, and of course.
Well, that's what I want.
We want to do.
How much more time do you think you need?
I think I need another 10 minutes. I'll try and be as fast as I can. And of course, we do need to deal with relief, although we have got a note that we can hand up to your lordship.
I see. What were we going to hear from Ms. Patel before 12:30 as well, were we?
Well, we do have a note, and we'll try.
No, but sorry, but that was the plan.
That was the plan.
Yes, I see. Okay. Well, I'm not going to make a decision on the hoof. I think you better go on with your submission on how we will deal with this, whether we'll take off your reply or whether we'll sit a bit later. It's something that we can decide now, but I think you'll have to be economical.
Yes, indeed. So the restructuring provision, and I think I might just invite your lordships to read bits of guidance I will refer to, and I'll give your lordships the note. Fundamental, so Article 367 of the TCA, which is at page 3686 of the authorities bundle in tab 99, I think. But anyway, page 3686. So you see, your lordships will see there, the key bit is, for our purposes, is the requirement which you see in the final sentence, except for small and medium-sized enterprise, an economic actor or its owners shall contribute significantly.
So sorry, I'm looking at 3686.
3686, paragraph
Final
3,
sentence.
and it's the final sentence beginning
For the purposes of this paragraph.
Yes. Except for...
Oh, sorry, you mean the anti-penultimate, the penultimate sentence?
Oh, the anti-penultimate.
No,
I missed it.
It's the sentence except...
The sentence beginning except for.
Yep, okay, got it, yep. Thank you, sorry.
So, shall contribute significant funds. And it's accepted that that was a requirement of a lawful restructuring aid, assuming that the Article 367 applied. So the question is, what is significant? And what does significant mean in this context? And there are guidelines issued by the Commission in 2014, so guidelines with which the UK was well familiar at the time of negotiating the provisions of TCA, sets out and explains the significant test. And that's at tab 106, page 4065. And it regards significance as an element of the proportionality assessment. And critically, what it says is that significant means at least 50%.
What was the page? What was the page?
Page 4065 in the authorities bundle.
Okay, well, I don't think we need to go to that.
But I will tell you what I say about it, and your lordships can check the text when your lordships have a moment. So at least 50%. And there are exceptional circumstances where a figure of less than 50% has been acceptable, but none of those fall below 40%. And there's a convenient list of cases in Helen Bacon's book, the relevant page of which is, I think, at the final page of the authorities bundle, with a footnote to that effect. Now, the Bayes guidelines, again, I will refrain from them, but give your lordship the reference. Page 3841 in tab 102 of the authorities bundle uses very similar language in talking about significance. And again, we say the Bayes guidance must be meaning the same thing. Otherwise, you'd expect a footnote stating different. Now, there's no suggestion in either set of guidance that it's relevant to the question of whether a contribution is significant, that the purchaser is the only one left standing after a competitive process, nor is it said to be relevant that the state contribution might, in favourable circumstances, turn out to be a bit less than expected at the time the subsidy was awarded. And then, so that's the background. When you look at the subsidy control assessment, it makes no real attempt to balance off the value of the subsidy, which is examined in detail, as your lordships will recall at the beginning of the assessment, page 619, with all the figures, against the contribution by Octopus, which figure that your lordships have, which I won't read out, but your lordships have it in mind. And in particular, if your lordships, I do want just quickly to take your lordships to this, in the subsidy control assessment, which I hope your lordships have already got open, page 369B, the subsidy control assessment, you see, gives the figures, and then about halfway down paragraph B says,
which page?
Page 639 of the subsidy control assessment. It says, while this is below the 50% of restructuring costs referred to in the SCA guidance and EU state aid precedent, there is no such specification in the TCA, which is the regime we are currently under. So that's the reasoning adopted by the Secretary of State. And as to that sentence, I make 2 points. First of all, that below 50% is, in the context of the figures we've given, a masterly bit of Whitehall understatement. It's very much south of 50%. And secondly, what is actually being said here is the reason why we think this threshold either doesn't matter or has been overcome is because we're in the TCA regime.
Yeah, well, you said that. Well,
and
why is that wrong?
We say that's unsustainable, given the...
Okay, so you say that's wrong?
That's wrong. That's simply wrong. It can't be relevant, given the admission that the Subsidy Control Act, there's simply no basis for saying the TCA control is weaker than the SCA or EU law was. So that's the point. Yeah. I think I'm just wondering if there's any other point. And just before sitting down on this point, I just want to emphasise the point that these restructuring provisions of the Trade and Cooperation Agreement are a prohibition. They're designed to prohibit things, and it's in principle no answer to a prohibition to say, but we're stuck, and any other solution would have taken time or money to resolve. So we accept that even assuming that the bid process had been open and transparent, etc., it was always, in principle, possible that you'd end up with a situation that no purchaser was prepared to purchase at the price of making a significant contribution. That was always a certain conceptual possibility. And in those circumstances, what the prohibition would have meant is that it just would have been impossible to grant subsidy on this in this sort of arrangement. The government would have had to have used its legal powers and resources to find some other solution. That is the effect of a prohibition on restructuring subsidy. It does mean that subsidies are prohibited and other solutions have to be found.
Yes.
And so if the government says, well, it all would have been very difficult had we not been allowed to.
You're repeating yourself when the time is short.
Indeed, and I'm now going to sit down.
Well, you're not for a moment, because I'm just going to ask you about how the Divisional Court dealt with this.
Yes.
Am I right in thinking we haven't been taken to it? But
no, I would have done. It's paragraph.
Well, don't worry. It's 275 and 276, isn't it?
Yeah.
I was just interested that the reasoning at 2762 says we are satisfied that this was an assessment reasonably open to the Secretary of State. Is that the correct approach?
No.
Right.
And we say it's a question for, well, first question for the court to determine. First, again, subject to the points made by Mr. Beale about the court.
Yeah, well, that's what I wanted.
Etc. There are obviously two questions here. There's one of which doesn't really arise because we accept that there was an emergency.
Well, you've made that one. Yes,
the question of whether it was a response to the emergency, we say, is a question of law for the court, and the court can and should say if it's a mistake, then they should correct that. Yes.
So you say it's not actually right for Mr. Beale's reasons, but actually, in a sense, it doesn't so much. This isn't your main area of criticism.
Yes.
The main area of criticism is the one you've just developed.
Indeed, it is.
Okay, thank you.
Indeed, it is.
Can I just ask this proposition, just looking at what's a national economic emergency and what's prohibited, does the fact that if your analysis is right, no bidder in their right mind was going to make a bid for these customers, leaving 1.5 million customers out in the cold, suggest that it was a national economic emergency, or is that muddling concept?
I think it's muddling concepts. I mean, there will be situations, and I'd say the prohibition on restructuring subsidy gives rise to this. There will be situations where a business goes down, and even though that is going to have serious effects on a large number of people, the restructuring and if it didn't, you wouldn't be allowed to have a restructuring subsidy at all because it's got to be a public policy objective. So even where would be a perfectly proper public policy objective for the subsidy, the restructuring prohibition nonetheless prohibits it. And the answer is the government just has to find other means of doing it. I mean, governments have, a whole range of legal powers and resources, and it may, from some policy perspectives, be the less optimal way of doing it, but that is what the parties agreed in the Trade and Cooperation Agreement. They agreed that in some circumstances they would tie their hands and forswear restructuring subsidy.
Thank you.
Yes. Now, relief. Now, Ms. Patel, we say you got a note. Is this a note that anyone else has seen?
No, my lord, it was prepared in the event I was squeezed for time, which I think I am, so it hasn't been handed up yet or circulated.
It's not very satisfactory because it's not very well put in a note, but we might need to ask you questions about it.
I think having discussed it with Mr. Beale, given where we are with timing, we would suggest that we're happy to answer any questions in reply rather than addressing you.
Well, I think the sensible course, rather than spend time on it now, is why not hand up the note? We will look at it over the short adjournment, and that will also give the respondents the chance to do so and decide how it is best to be dealt with. Thank you. I can't remember what is said about relief in the Stellarton argument. Is anything? Not much, is
In the
it?
skeleton arguments for this hearing?
Yes.
No, I think the fullest submissions are in the note prepared for the permission to appeal hearing before my Lord and Lady Justice Whipple. But there is not much in the skeletons for this hearing.
Right, and presumably below, obviously, as we were told.
Well, there is a little in below. The note tries to set out the references to what there is below.
Yes, I see.
Which, in summary, I mean, the remedies that were sought in the claim form are set out at paragraph 2. But two key points. At the end of paragraph 2, you'll see that when you turn up the British Gas amended statement of facts and grounds, recovery was expressly not limited to the unwinding of the transaction below. At paragraph 3, when you look at the amended statements of facts and grounds for E.ON and Scottish Power, you'll see that E.ON...
Well, sorry, having said I didn't want to be... I think we will have a look at this and we'll decide how to handle it.
The short answer to your point, the skeleton for this hearing, relief is dealt with at paragraph 74 of the joint skeleton argument, which is page 866 of the core bundle.
Thank you. Yes. Thank you very much. Right, now, who are we hearing from first? You, Mr. Coppell.
It's me, my lord. I have just a moment to arrange myself.
Do you need this?
No, thank you. My lord, the Secretary of State submits that the appeal should be dismissed. In order for the claims to succeed at this stage...
Sorry, just before you get going, how are you dividing up your time between yourself and the other respondents or interested parties?
So, according to the timetable,
I'm sorry, I thought the timetable didn't spell this out. Maybe it did, and I've lost it.
I think it may have done. I'm due to speak until midday tomorrow.
Yes, I see.
And then Mr. Hickman has a nominal hour and a half, and then Lord Panic has a nominal hour. But we'll see how we.
Nominal. What do you mean by that?
Well, in the sense that if I don't take my whole time, or if I take a bit more than my time, they'll need to be.
They're going to fit in with you, basically. Yes, I see.
Yes.
Okay, thank you. I just wanted to know what
up to a point.
Thank you.
So I intend to speak for the rest of the afternoon and then to resume tomorrow morning.
Yes, okay. Well, off you go.
Much of the morning. So we say the appeal should be dismissed. In order for the claims to succeed at this stage, we say that the claimants must establish each of a series of unlikely propositions. Firstly, that the Divisional Court was wrong to consider that unreasonable delay on their part could justify the refusal of permission to bring their claim on the TCA as well as their claim on public law grounds, those being at that time claims primarily for quashing relief. As in the Divisional Court, Mr. Hickman for the administrators is going to take the lead on that aspect, and I'm going to prospectively adopt what he says.
So Mr. Hickman's going to deal with what, the whole of the delay question?
Yes.
Right.
The second unlikely proposition submit is that the effect of the TCA, read with section 29 of the EU Future Relations Act, is to enact the subsidy control provisions of the TCA into domestic law as if they were a domestic statute.
Why is that an unlikely proposition?
Well, I'll come on to explain that a little bit. Can I summarise my
This
case?
is the trouble with trailing submissions.
Stage.
I'll keep my mouth shut.
Trailing my submissions. Mr. Beale's case is these provisions are in effect a new domestic law statute which gives rise to a series of legal tests which are objective or hard-edged, which the court must decide for itself whether they are satisfied, rather than applying the usual public law approach to the standard or intensity of review, where government bodies exercise evaluative judgments on complex matters. We will submit...
But that's rolling up two different points, isn't it? There's a point about whether the TCA is incorporated effectively into English law as if it were an English statute. And there's a completely distinct point about what the standard of review is. One doesn't follow from the other.
Well, we say that if one properly understands how the TCA provisions come to be incorporated into domestic law, then the issue of standard of review does follow naturally. We have alternative submissions, of course, in the event that we're
okay, well, I'm sorry, I have a personal bugbear about trailing submissions, as I can't resist testing them when trailed, but
shall I just explain briefly what our submission is on the method of incorporation? We say the subsidy control principles are imported into domestic law as a public law standard to be applied by the Secretary of State when taking these decisions under the Energy Act 2004.
Sorry, imported into domestic law as a
public law standard to be applied along with other public law standards when the Secretary of State is taking decisions under the Energy Act. And that compliance with
hang on. Okay.
And that compliance with that standard is to be assessed in the conventional public law manner, which is Wednesbury Review. We say that is all that is necessary to implement the subsidy control provisions of the TCA, and so that is all that Section 29 requires. Alternatively, we say that the Divisional Court was right to apply a proportionality analysis, but affording a wide margin of discretion as appropriate to the context of these decisions.
So the first is a respondent's notice point, and then the alternative is just saying that the Divisional Court was right. Is that right?
Yes.
Yeah, okay.
The third unlikely proposition is that questions of whether an economic advantage has been conferred so as to give rise to a subsidy, that's Article 3631B, Roman 2, and whether a subsidy is proportionate and limited to what is necessary to achieve its objective, Article 3661B, require the importation from the EU state aid law of a requirement for an open, competitive and non-discriminatory tender process, compliance with which is to be judged by the court as a matter essentially of public law fairness, is how Mr. Beale put it, without affording any public law margin of judgment. That's their next proposition. We will submit there is no such requirement. The TCA subsidy control provisions do not import EU state aid law, and in any event there is no such requirement in EU state aid law. The relevant question asked and answered by the Secretary of State and in turn by the Divisional Court is whether the conduct of the M&A process, taken together with other relevant analysis, including benchmarking, analysis of counterfactuals, could rationally have been considered to have given rise to a market price for Bulb's business.
So again, that's rolling up two distinct points. One about whether this was an appropriate process, whether this process was capable of satisfying whatever the test in law is. And The second is whether we're only concerned with whether the Secretary of State rationally considered that it satisfied that test rather than whether it actually did satisfy that test. Is that right?
Well,
those are 2 points, aren't they?
They are a single point in this context because the test, the CMO test, expressly incorporates the rationality standard, and I'll show you that. So if you...
Well, don't explain it now,
no,
because this is just trailing. Okay.
And finally, my lords, and my final aspect of trailing, as it were, the claimant's case then rests on the proposition that when you are assessing compliance with this hard-edged standard of fairness, open, non-discriminatory, competitive tender process, that you must depart from a large number of findings of fact or of factual evaluation by the Divisional Court, which run directly contrary to the claimant's case that the process of sale of bulb was unequal and unfair. And we say which are findings which are fatal to their claim, no matter how strict a standard of review is adopted by court. To name a few of the more significant findings of the Divisional Court, the Divisional Court found that both British Gas and E.ON, and indeed others, were well aware of the potential availability of government support for a purchaser of bulb. That's how Mr. Beale put his case to the Divisional Court. That's what needed to be done, make bidders aware of the potential availability of government support. Also their case in writing for this court, expanded by Mr. Beale yesterday and this morning, he said what was required was that bidders be informed of the availability of government support for bulb's balance sheet and for hedging. Even if it were legitimate for the case to be amended in that way at this stage, the Divisional Court decided precisely that British Gas, E.ON, Scottish Power, the other claimant below, and other bidders, including Tulip, had been made aware of those very matters. Paragraph 39 for E.ON, for British Gas, paragraphs 45.
Are we going to get all these submissions again when you make them?
You're going to get...
It's one thing to give us the headline points, but if you're giving us references and so forth, now I don't know whether to write them down because we're never going to get them again.
I'll leave the references.
Yeah, okay.
The second significant factual finding that you are asked to overturn is the finding that Octopus was not given materially different information with regard to government support than British Gas or E.ON. It had, found the Divisional Court, simply reacted differently to the potential availability of government support of which the claimants were equally aware. Next finding of fact, that neither British Gas nor E.ON would have made a bid to buy bulb, even if the unfairness that they had alleged had not been present and they had been given exactly the same information as Octopus was at the same time as Octopus was given it. E.ON had reasons other than availability and extent of government support for not wishing to purchase bulb, found the Divisional Court. British Gas found the Divisional...
How is this material?
How is this material?
It's an unfair procedure. The fact that for other reasons they might not have bid anyway doesn't make it fairer, does it?
Well, the ultimate question, of course, is whether the process was adequate to secure a market value for bulb. A complaint by a bidder of unfairness when that bidder wouldn't have submitted a bid anyway is relevant to that question. Mr. Beale made a submission this morning about how British Gas were interested in bidding and only pulled out because of the lack of availability of government support being communicated to them. Again, the Divisional Court found in terms that British Gas were not interested in acquiring Bulb, but only in acquiring some of Bulb's customers. Now, if there was no other bidder, no other show in town than Octopus, nobody else interested in bidding, ultimately to buy Bulb, then that is highly significant, we say, and the Divisional Court agreed with us, highly significant to whether the process gave rise to a value which the market placed on Bulb at that stage. And finally, and we do say this is a finding of fact, or at least factual evaluation, the Divisional Court held that the administrator's conduct of the M&A process, taken together with other relevant information, benchmarking the counterfactuals and so forth, and a review by Ernst & Young, was a reliable basis for treating the Octopus bid as a fair reflection of the value which the market placed on Bulb. We say the Divisional Court held in terms that the provision of information to different parties at different times and in slightly but not materially different forms did not affect the reliability of the process as a means of establishing the market value of Bulb's business. All of that, we say you've got to overturn for these claims to succeed. Mr. Beale went so far as to suggest this morning that you could and should, with limited exceptions, apply the factual findings of the Divisional Court and reach the opposite conclusion to the conclusion that they reached. We say that is fanciful, and that it seriously underestimates the extent and the relevance of the inconsistency between the Appellants case and the facts found by the Divisional Court.
You've used on a few occasions the phrase, probably quite deliberately, the market value of Bulb, market value of the business. Do you say that's any different in these circumstances from the best price that was reasonably attainable in the market at the time?
Well, those are certainly very closely related questions in the context of this particular process. There was other analysis done. It wasn't simply what's the best. In fact, the only bid that we've had, that's the best price. Therefore, it's a market value. There was other analysis done, and the Divisional Court goes into into some detail about the different stages and different analyses that were done. But ultimately, the conclusion was that the best price which the market could come forward with at that time was a fair reflection of market value.
Right. But the bid process was designed, the sales process is designed to achieve the best price, isn't it? That's what the point of such a sales process is.
Yes.
Which was then, that was I think your point is that's right, but then that was checked, as it were.
That was cross-checked, yes. I wouldn't want the court to have the impression that we simply relied upon the process and the output of the process. There was a whole lot of other analysis done by way of cross-checking as well.
Well, I see the time. Let's say 2 o'clock.
Court rise and table.